Attorney General Morrissey, let me ask you a question. We obviously have a difference of opinion here. The Supreme Court recently said that it is skeptical, quote, when an agency claims to discover in a long extant statute an unheralded power to regulate a significant portion of the American economy. I guess my question is, how long has 111D existed, and has it ever been used outside the fence line to overhaul an entire sector?
Mr. Chairman, this actually is literally an unprecedented effort on the part of the EPA to regulate. And we've looked very closely, and we have never seen a proposal quite like this, both in terms of its scope and its willingness to regulate outside the fence, but also the legal theory that's being advanced here by this administration. If you go back to 1970 and then you go up all the way to modern day, to today, you're looking at nothing that's ever occurred quite like this. Now, there have been some select efforts to rely on 111D in very limited circumstances, but nothing ever approaching this magnitude. And the other critical point is that from 1990, no federal agency, no one has ever questioned that if you were to regulate under 112, that the literal text would ultimately preclude the state-by-state emission targets that are being set under 111D. So we think that this is really an unprecedented approach, and we would also add that what the administration is trying to do here is rely on a typo, a conforming error, if you will, in order to breathe life into one of the most sweeping regulations in our country's history. If you look to advance something that has this great an impact on the American economy, at a minimum, there should be clear authority and not a reliance on this typo.
Thank you. Mr. Martello, you mentioned in your statement, I believe, that EPA had never gone that far in terms of this fence line issue. Could you respond to that question as well?
Thank you, Madam Chair. That is correct. There have been a number of occasions where EPA in the past has looked at something called a bubble concept, and that sounds like exactly what it is, that you can sometimes bring in the notion that something's more than just a stack and you bring in other sources of that bubble. There's two cases that address that, and both rejected the bubble concept, and those weren't even in the Section 111D context. So the little bit we've seen of this in the courts has been negative and pessimistic on that. In terms of your question on Section 111D, EPA has engaged in 5 Section 111D rulemakings since 1990. In each single case, it has always stayed strictly within the fence line. The analogous fence line's never gone outside of it. So there is a lack of precedent from the agency and a consistent source of case law that would suggest that everything has to be within the fence, and frankly, that's the clear reading of the statute as well.
Thank you. Attorney General Pruitt, the proposed rule is clearly on shaky grounds, and I believe Mr. Martello said 4 years before we would actually maybe get a firm legal interpretation of it being finalized. So what happens if states start implementing the final rule, only to have the court strike the rule down? What do? I mean, if people are going to start signing contracts and breaking ground, what kind of scenario does that present to you in your mind?
Madam Chairwoman, I think it's a great question, because what's not been discussed this morning is the short timeline that the EPA is likely going to propose when they finalize the rule next month. It's our understanding that it's going to be a 1-year compliance period for states to submit a state implementation plan, and by any estimation, that is a very ambitious timeline. As such, I think what is happening across the country is respective departments of environmental quality at the state level feel as though they're being pressured, intimidated, to comply with a rule that perhaps is not consistent with the statutory construction, which is the purpose of our discussion here today. I'm very concerned about the timeline. And I would add to Roger's comment earlier, we have to keep in mind, in fact, one of my fellow panelists is a public utility corporation. She regulates this at the state level. The regulation of energy generation is a police power of the states. It's historically been recognized as such through court cases. And for there to be any intervention into that police power, there's a rule of statutory construction that Congress speak explicitly, clearly, unambiguously to the authority of the agency to invade that police power that has been recognized under the law. And I think by virtue of the discussion here today, even among the panelists, there's disagreement about whether this statute clearly provides that type of authority.
Another quick question, and I think your governor has said that she will not be doing a state implementation plan. Is that correct?
There was an executive order recently issued by the governor indicating that the DEQ is not empowered to submit an invalid plan to the EPA.
Okay, and I believe in West Virginia, Mr. Attorney General, that the state legislature weighed in on this. Could you talk about that just for a minute?
Yes, just recently, a couple months ago, the state legislature changed the law so that for the state of West Virginia to submit a state implementation plan, the legislature would have to ratify it. That's different from the previous law, which would leave all that authority to the governor.
All right, thank you.